Lord, page 1, para 1, Lord. In a parliamentary democracy, the cabinet and the chief minister must enjoy and must continue to enjoy the majority support of the house at any given point of time. It is the constitutional obligation of the governor to ensure that government is stable and the government as well as chief minister enjoys majority support in the house. The argument, my lord, third, right now your lordships may ignore, I'll come to it a little later. 4. The question as to whether the government or chief minister has lost confidence or support of the house is not to be decided by the governor and shall have to be decided on the floor of the house. The governor, based upon the material from wherever derived, well, this expression I have borrowed from Bomai, from wherever derived, because this was an expression used by the committee of governors appointed in 70s, and Bomai has approved that report, my lord, can only arrive at a conclusion that prima facie the cabinet or the chief minister has lost confidence, support of the house, which requires to be tested on the floor of the house. His satisfaction is limited only to the requirement of floor test and not whether A enjoys majority or B enjoys majority. Now, my lord, your lordship's very pertinent question was that if, I'm sorry, my lord, your lordship, sorry, that merely because there is some internal dissatisfaction amongst the party, can the governor take this call or not? My lord, a similar question arose, my lord, in case of Rameshwar Prasad, where the question was that you're permitting somebody to request you to hold a floor test would violate 10th schedule. Because what these people, this group who is expressing no confidence against the chief minister, stand disqualified or will stand disqualified under the 10th schedule. And the question before the court was whether the governor, while taking a decision under say Article 174 and 175, is concerned what will be the effect of their act ultimately in the 10th schedule. I hope I'm able to make myself clear. While taking the decision, I am supposed to be cognizant that what they are doing might be a reason for 10th schedule punishment, a consequence subsequently. Your lordships, my lord, through a constitution bench says no. My lord, please take, my lord, Lord, 2006, volume 2, SCC, page 1. I'll read only 4 paragraphs on this point. That governor is agnostic to 10th schedule. He has to be satisfied that the confidence is lost prima facie. It needs to be tested on the floor. They may suffer consequence, they may not suffer consequence. That's not the governor for the governor to see. That's what your lordships have said. Lord, kindly see PDF page 393 in JC volume 1.
There are two important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed
which brings it down to your lordships. So
out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a 3-party coalition, the dissension has taken in one party out of the 3. The other 2 are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the 3 are virtually at par, except the Congress, which was a little lower.
May I only make one request? Look, to examine the facts of the case, after, my lord, I show the law, your lordships are shown, but some of the paragraphs, some of the law is unfortunately not assisted.
2006.
Thereafter also, my lord, why the governor can take that step even if NCP Congress bloc is not disturbed. I'll, my lord, answer that. My lord, it is para,
What is the citation, Mr.
my lord, 2006, volume 2, SCC, page 1, para 85.
Which compilation is it?
The judgment compilation 1. My lord, PDF page 482.
Starts from page 393.
Yes, ma'am. Yes.
So to go to 482.
482, my lord. Para 85. I am reading 85, 161, 164 and 165, which is on this point, my lord. And my lord, kindly bear one factor in mind. My lord, whether the court would have taken the same view which the governor took may not be the test while determining, my lord, the decision taken by the governor. Court may perhaps on the facts arrive at a different conclusion. Lord, 85. Certainly there can be no quarrel with the principle laid down in Quixote case about the evil effects of defections, but the same have no relevance for determination of the point in issue. The stage of preventing members to vote against the declared policies of the political party to which they belong had not reached. If MLAs vote in a manner so as to run the risk of getting disqualified, it is for them to face the legal consequences. That stage had not reached. In fact, the reports of the governor intended to forestall any voting and staking the claim to form the government. Well, this was a case of 356. He sent a report that now dissolve the government. Yes.
The stark distinction so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections.
Correct.
Where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the governor has drawn. But as against Rameshwar Prasad's case, this is a case where the government is subsisting for more than 3.5 years. So that's the distinction between Rameshwar and ours. I'm just putting it to you.
That's yes, but the legal proposition which I would, my lord, place for your lordship's consideration may be the same. The consequence which would, the power of the governor or the exercise of power of the governor at the time of initial formation or subsequent shall have to be the same. That's my respectful submission. Please come to, my lord, now PDF page 520 at para 161. Because I, my lord, with profound respect, do not see any, my lord, any reason to not read this ratio for exercise of power under 174 and 175 also. This was also the case where the Supreme Court said you should have called for the floor test. You could not have said that, no, they might incur disqualification. 161, my lord, if your lordships, my lord, can. We are not, your lordships gets that, my lord. We are not impressed with the argument based on a possible disqualification under the 10th schedule if the MLAs belonging to LJP party had supported the claim of so-and-so to form the government. At the stage, it was wholly extraneous to take into consideration that some of the members would incur disqualification if they supported a particular party against the professed stand of the political party to which they belong. The intricate question as to whether the case would fall within the permissible category of a merger or not could not have been taken into consideration, assuming that it did not fall in the permissible arena of merger and the MLAs would earn the risk of disqualification. It is for the MLAs or the appropriate functionary to decide and not the governor to assume disqualification and thereby prevent staking of the claim by recommending dissolution. My lord, your lordships are right. My lord Justice Narasimha are right. Fact situation was 356. But why, my lord, I am posing a question to myself. This ratio not apply when the governor decides to call for a floor test, which your lordship said is the only test. Lord, further, it is not necessary for us to examine for the present purpose para 4 of the 10th schedule dealing with merger and or deemed merger. In this view of the question sought to be raised, my Lord, kindly see the last line. It could not have been gone into by the governor for recommending dissolution. My Lord, what fell from my Lord the Chief Justice would be, my Lord, if I put it in the context of this ratio, would be that the governor will have to first form an opinion that these people are working since 3 years. They have a reason to, they have shown the reason to the governor why they are parting ways after 3 years. But can they do it after 3 years? Would it not amount to a split? Would it not amount to disqualification under Chapter 10, Schedule 10? Now, kindly come to my Lord 160. 162, my Lord. The provision of the 10th schedule dealing with defections, those of the RP Act dealing with corrupt practice, electoral offences and disqualification, etc., and are legal safeguards available for ensuring purity of public life in democracy. But insofar as the present case is concerned, this had no relevance at the stage when the dissolution of the assembly was recommended without existence of any material whatsoever. There was no material for the assumption that claim may be staked based on democratic principles, but based on manipulation by breaking political parties. Now kindly come to my Lord 164 and 165. It is true. Does your Lordship have that? It is true that, and kindly, my Lord, for my satisfaction, read it as 174, 175 instead of 356. It is true, as has been repeatedly opined in various reports and by various constitutional experts, that defections have been a bane of Indian democracy. But at the same time, it is to be remembered that defections have to be dealt with in the manner permissible in law.